Maybe let's I beg to mention, I beg to mention for listing one motion matter, my lord. Earlier, three times I listed my lord and directed the petitioner to produce the complete voter list. Accordingly, petitioner submitted by way of affidavit, my lord. Thereafter, case is not listed, my lord.
Monday?
Yes.
Wait, please, Your Lordship. I'm praying for listing of the unlisted matter on tomorrow, Lordship.
Why?
Petitioner is under detention center, Lordship.
Since when? Since when?
31/10/2023, Lordship.
Monday.
Deeply obliged, Lordship.
I have a single prayer, my lord. The petitioner is in detention camp, my lord.
Monday.
Monday.
When did you file? When did you file? When you have filed?
Yesterday, Lordship.
You have filed. You have the
Yes.
filing number.
Yes, Lordship.
What
Yes,
is it?
I have also one.
Lordship, I beg to mention item 4 and 5. Normally, the petitioner before your lordship, his sister is also
Just a minute. This those who are in detention, those two matters tomorrow.
Tomorrow.
Lordship, I beg to mention item 4 and 5 for an adjournment on the ground that the petitioner's sister's case is also pending before this court, and the annexures are almost similar. Plus, some few extra documents are also there in
Please
the
tell the
sister's.
number. Now, please give us the number.
Yes, Lordship, that is WPC 5570 of 2019.
On the prayer of the council for the petitioner. List these matters along with WPC 5570/2017
Lordship, 19.
on 6th of December.
Obliged.
May please, Lordship, I beg to mention item number 1. Lordship, kindly pass over the date.
Why?
As per instruction of my senior, the instruction may be required from the client.
Hold on. Let the matter reach. These are item number 1 and these are 2017 matters. Wait for your turn.
May it please the Lordship. My lord, the father of the petitioner, my lord, is a voter of 1966, my lord, page number 15, 15. And as well as 71 also, her father is a voter, my lord, page number 19, Kasam Ali, my lord. So far link is concerned, my lord, I have annexed, my lord, 4 numbers of documents which were executed, my lord, exhibited. My lord, page number 21, Panchayat certificate, Gabora certificate, Aadhaar card, PAN card. My lord, all the documents, father names are included, is included, my lord. In this case, my lord, her own brother was examined, my lord, who was DW2, and he is declared Indian, my lord, earlier. And I have annexed the order, my lord.
Yeah. Copy order. Hmm?
Ask. Hey, it's 20. Next.
Yes, Mr. Ali, where is the illegality in this order?
My lord, the petitioner's father's name appeared in the voter list of 1966, and she is having linked document with her father, my lord. And her own brother was declared Indian, my lord, and as per an order, my lord, which I have annexed, my lord.
The tribunal has discussed all these issues.
But my lord, actually there is
That
no
the reason we
valid,
are asking you.
actually,
Show us how is the.
no reasonable
illegality
ground, my
occurred.
lord.
How the
To,
illegality occurred, kindly tell us.
my lord, in fact, my lord, there is no point, my lord, why, my lord, he has been declared a foreigner, my lord. Because, my lord, he is having all the documents, my lord. But
Having the documents is definitely, you might have hundreds of documents, but you'll be required to prove as per the procedure of law. Now, that is the reason we are asking you,
my lord,
where is the illegality in this part of the order? Why you are saying that tribunal has committed illegality? Where is that issue? Deciding the proceeding to be a foreigner, yes, there has to be some basis. You have submitted some documents, but the tribunal did not consider certain documents which you have placed before it
Hmm.
and rejected it. Tribunal found there altogether 14 such documents you have placed before the tribunal.
my lord,
And the tribunal has considered each and every one,
my lord.
all those 42. Now just tell us, where is that illegality by which the finding the tribunal has committed the illegality? He has discussed all the 14 exhibits, right?
Discussed but not considered, my lord.
No, why? If not, what was the finding of
My
the
lord.
tribunal?
My lord, actually, my lord, the Panchayat authority, my lord, should have been
No, that is not, we are not on that. Just tell us, where is the illegality on the part of the tribunal in rejecting your exhibits?
the illegality is that, my lord, the tribunal failed to consider the link with her father, my lord. whose name
Tribunal
is-
failed to consider, or it is the prosecutor who failed to establish our case before the trial?
I established because, my
Like
lord,
what,
my
like
brother,
this?
my brother was declared Indian
Right.
and who has been examined, my lord, as DW2.
Right, you have said that your brother has been considered to be an Indian national or as not a foreigner or illegal migrant. by
And,
their-
and he has been examined.
Now, what is the statement? That's why we are asking you. When he was examined by the tribunal, you produced him as your witness, right? So, what is the finding in that figure? Just read in the order. Tell us why the reason for rejecting that particular witness, submitting on your behalf. Where is the
My lord,
illegality?
My lord,
First
so
was
far,
the illegality.
so far the that witness is concerned, my lord, no discussion, my lord.
Can you see the order? Don't make a submission like that without going through the. I think. Read page 46.
My lord. The opposite party to prove her case has produced a witness, Nur Islam, stated to be her younger brother. In her evidence, he has stated that a IMDT case number so and so was initiated against his brother Nur Islam, so Kasem Ali, a son of Kasem Ali, the learned chairman IMDT Tribunal Doromongoloi fight order dated so and so was pleased to help that the opposite party Nur Islam is not a illegal migrant. The final order dated so and so read as follows. OP Nur Islam is present. Peruse the written statement filed. The OP claims that his father Kasem Ali was a voter in 1966 in Dolgaon Assembly constituency. He has filed a copy of the electoral roll. I am satisfied from the above that the OP is not an illegal migrant, my lord.
Go on, read.
During cross-examination, the witness has stated that he did not produce any witness and no advocate was engaged on his behalf. He also stated that he did not submit any written statement and have submitted only some Xerox copies, documents before IMTT Dorong. Moreover, in that case, the name of the father of Nur Islam was recorded as Kasem Ali and not as Kasam Ali found in this instant case. Therefore, this tribunal cannot consider that Nur Islam and the opposite party, Nur Islam and the opposite as brother and sister. The evidence of the witness evidence is not accepted as does not corroborated by any reliable, acceptable, and dependable materials. This tribunal also finds that all the documents that the opposite party has uh, submitted were not proved as required under the Law of Evidence 1872. The apex court in case of LICI and another versus
Rampal Singh.
Rampal Singh reported in 2010 for SCC 491 has laid down that the contents of the documents are required to be proved and mere marking of the documents as exhibit does not amount to proof. The written statement of the opposite party is wholly inadequate and did not disclose any material fact. As noted above, it was the allegation of the state that the petitioner was a foreigner. Therefore, as per mandate of Section 9 of the Foreigners Act 1946, it was the burden duty to the petitioner to have disclosed all the materials facts which were specifically within the knowledge of the written statement, but he did not do so.
Read paraphrase 47.
A written statement is the basic statement of evidence of a proceeding before the FT where her citizenship is questioned by the state. He has to dispose of all the uh, relevant facts which are within her special knowledge and which are materials to the question of the citizenship at the first instant itself. That is in the WS, it is a settled provision of law that the variation between pleading and proof is not permissible. A proceeding cannot travel beyond this pleading. That part, mere filing of WS is not enough. Averments made in the WS required to be proved by adducing cogent of the reliable evidence. Section 9 of Foreigners Act 1946 mandates that it is the burden of the proceeding to prove the adducing cogent and reliable evidence that he is not a foreigner but a citizen of India. In Sarvananda Sonowal versus Union of India, 2005 5 SCC 665, Supreme Court examined in details that the requirements of Section 9 of the Foreigners Act 1946 and held that there is good and sound reason placing the burden of proof upon the person concerned who asserts to be a citizen of a particular country. In order to establish one's citizenship, normally he may be required to give evidence of his date of birth, place of birth, name of parents, their place of birth and citizenship. Sometimes the place of birth of the uh, grandparents may also be relevant. All these facts would necessarily be within the personal knowledge of the person concerned and not of the authorities of the state. Supreme Court of India held that this is in accordance with law, the and their underlying policy of Section 106 of the Evidence Act, which says that when any fact is specifically within the knowledge of any person, the burden of proving that fact is upon him. Therefore, the opposite party has failed to establish her claim to be an Indian citizenship by producing reliable, cogent, documentary evidence of proof that she is an Indian citizen. The narrative presented by the opposite party suffers from multiple materials, contradictions, and omission, rendering the same highly suspect and wholly improbable. Thus, the opposite party has failed to discharge her burden under Section 9 of the Foreigners Act 1946 to prove that he is not a foreigner but a citizen of India. Hence, it is found that the opposite party have failed to prove the adducing any evidence admissible or otherwise to prove her linkage with her father, Kasam Ali, whom she claimed to be her father, reliable to be a period to 25/3/1971.
Please come to page number 42. Read from the second paragraph.
On perusal of written statement, the evidence and the documents, it is found that the opposite party have exhibited various documents and among them he had exhibited 14 documents to prove that she is not a foreigner but a citizen of India. Exhibit 1 and 2 are the voter list of 1966 under 66 and 71 Dolgaon LSE of village Jamalpur, PS Dolgaon. The voters are Kasam Ali, son of Mohir, aged about 42 years, and Bibhishan Khatun, wife of Kasam, aged about 34 years. The opposite party, in her written statement and in her evidence in chief, she stated that Kasam Ali is her father and that Bibhishan Khatun is her mother. These documents are not proof as required under law of evidence in Nargoda Devi Gupta versus Birendra Kumar Jaiswal, 2003, 8 SCC 745, Supreme Court related the legal position of marking of documents as exhibit and their proof are two different legal concepts. Mere production and making of a document as exhibit cannot be held to be due proof of its contents. Its execution has to be proved by admissible evidence, that is by evidence of those persons who can for the truth of the fact in issue. Exhibit 3, 4, and 5 are computer generated statement of NRC details stated to have been obtained from the Office of State Coordinator NRC in the name of Kasam Ali and Bibhishan Khatun without entering into the other aspects of the matter. It can be stated that such a computer generated statement without the clarification of the respective officer of the department would have no evidentiary value. Having regard to the provisions contained in section 65B4 of the Evidence Act 1872, this aspect of the matter has been clearly by the Honorable Supreme Court in the case of Anwar PV versus PK Bashir, 2014, 10 SCC 473. Exhibit C is the Xerox copy of the order dated 29/11/2000, passed by learned chairman of IMDT Dorong in case of 1673/2000. Exhibit 7A are the voter list of 1997 and 2013 under 68 Dolgaon LSC of village Dolgaon Kuti. The voters in these voter list are Mavia Beba, wife of Ramzan Ali, and Mustafa Ali, son of Ramzan Ali. Mavia Beba is the opposite party herself, and Mustafa Ali is her son. As stated above, these voter lists are also not proved as required under the law of evidence. Exhibit 9 is the voter identity card in favor of Mavia Beba. In so far this document is concerned, besides no proof, this is a post 25/371 document. It has been held by the coordinate bench of Guwahati High Court in WPC number C547/2016, MD Babul Islam versus State of Assam, that merely producing a voter ID card in absence of supporting evidence would not be a proof of citizenship. Exhibit 10 is a certificate dated 16/12/2021 issued by the Gaugura of Dolgaon Kuti, certifying that the opposite party is the wife of Ramzan Ali of village Dolgaon Kuti. This certificate does not prove that Mavia Beba was the daughter of Kasam Ali. This certificate only shows that the opposite party was wife of Ramzan Ali and resident of Dolgaon Kuti. Further, in adducing to the deleted issuance of such certificate, the Gaugura did not depose before the tribunal to prove the certificate as well as the contents thereof. Such certificate would have no probative value. Therefore, the certificate is not proved. Exhibit 10 is a PAN card issued in favor in the name of Mavia Beba. This PAN card was obtained on 12/11/2017, that is during the pendency of the case, only to suit the purpose. The opposite party has stated in her evidence that she is a housewife and she is also not an income tax payee. There is nothing on record to show filing of income tax return on any point of time. Moreover, the authority who is alleged issued the PAN card is not produced to the tribunal to prove the fact. In absence thereof, no relevant can be placed on the PAN card as valid place of evidence. Exhibit 12 is an Aadhaar card issued in the name of Mavia Beba, wife of Kasam Ali. This document is also a post 25/3/1971 document, and by this document, one cannot prove her citizenship. Exhibit 13 is a certificate dated 26/6/15 issued by the Secretary number 5 Durwazar Gautama, certifying that the opposite party is the daughter of Kasam Ali of Jamalpur village. at the top of the certificate, Government of Assam was prominently printed. It was also mentioned in the certificate that the same was issued on the basis of the evidence placed before the secretary. This document has not appeared to be genuine document in as much as Gao Panchayat is not a department of government of Assam. Therefore, Gao Panchayat is not authorized to use the letter had with government of Assam printed therein. Secondly, the secretary of Gao Panchayat did not testify before the tribunal along with the evidence on the basis of where the certificate was issued to prove the certificate as well as the content thereof. In Rubjan Begum versus Union of India 2019, 1 SCC 579 held that such a certificate of the Gao Panchayat secretary is by no means proof citizenship. Exhibit 14 is a voter identity card issued in favor of Nur Islam, son of Kasem Ali. This is also a post 25/371 document. And may I be producing a voter identity card, as stated earlier, would not be a proof of citizenship. The learned additional government pleader appearing on behalf of the state have submitted that, according to the opposite party, her father expired when the opposite party was about 10 years old, that is 1964. And her mother also expired 2-3 years before before her father, that is 1961 and 1962. But opposite party failed to produce any voter list of her father after 1971. As the date of birth of the opposite party was 28/1963, then by 1981, she would be eligible to cast her vote. But as per her own statement, she have casted her vote first vote only in 1997. Moreover, she has to explain the gap period. The learned additional government leader further stated that except the PAN card, Aadhaar card, and Gao Panchayat certificate, which are all post 1971 documents, there is nothing on record to show that she is the daughter of Kasem Ali. She also failed to produce a single land document of her parents to show that her parents were in parents were in Indian soil after 1971, since her parents were shown to be resident of India prior to 1966. The opposite party, to prove her case, has produced a witness, Nur Islam. But I have already read.
Now, after completion of this, since you have considered, you have just read all the exhibits considered by the tribunal and the
Well-
finding given by the tribunal.
My lord,
Now, just
tribunal,
tell us, Mr. Ali, where is the illegality?
my lord, tribunal observed that Kasem Ali and Kasem Ali,
Ah.
that word, Kasem Ali and Kasem Ali, the same person, the some spelling mistake is there, E and A, my lord. So, my lord, that,
Where is your return statement?
my lord, written statement and my lord, the
We annex the
evidences,
written
my lord, we applied, but those are not furnished to me. My lord, I have stated that, my lord. My lord, on the next occasion, I can produce, my lord, page number, Lord, may kindly see page number 8, my lord, first page number 8, para 6, my lord. I have stated that the documents, my lord, which I could not produce, my lord, I will produce by filing an additional affidavit or like that, my lord, because I mean, problem, my lord, is a female person, she is outside. Every day, my lord, police search her.
Read para 3 of your read petition.
The name of petitioner's father, Kasem Ali alias Kasem Ali, it will be Kasem Ali.
Now,
Was
you are
issued-
saying, but she has saying something else. Read para 5.
MD Nur Islam, son of Kasem Ali, is the own brother of the petitioner who was declared Indian as per order dated 29/11/2000 in identity case number 1673/2000.
That where you have mentioned Kasem or Kasam. Now, come to the voter list. First, you have to establish your case.
My lord, I actually tried to establish,
Please
my lord,
come to page number 28.
page number 28, my lord, I have annexed this voter list, my lord, by showing the name of my brother, Nur Islam.
So
My lord,
now,
down below, my lord, I have marked Nur Islam, son of Qasim Ali.
Ah.
He is my brother, my lord.
now in the evidence, whether said Nur Islam stated that he was a voter.
My lord, I could not
He
collect the
said he
copy
had
of
cast
it.
vote, right? He said he had cut vote. It is there, you have just read. Now, if he has cut votes, then come to page number 29. Serial number 54.
Yes, my lord. Nur Islam, son of,
He is not a voter.
yes, yes.
He is not a voter. The second Nur Islam in that particular voter list that you have placed before.
Nur
the tribunal.
Islam, my lord,
So,
Nur Islam,
in your evidence, whether you have stated so that his brother, her brother, is Nur Islam.
my lord, here, my lord, Nur Islam, D is not given, my lord, maybe, my lord, printing mistake of the authority, my lord, he is not responsible for that, my lord. My lord, because she is a D voter, my lord, it is
She
admitted.
is
my
a
lord.
voter. What about her brother?
Her brother is a D voter, sorry, my lord. Her brother, D
Where
is
is
marked,
that?
my lord. D is marked page number 28, but 29 page, my lord, D is not mentioned in 2010 voter list, my lord. Maybe type mistake, my lord. D may not be there, my lord. But father's name is same, Qasim Ali, Nur Islam's father same, and the petitioner's father. Same father, my lord.
Tell us where is the illegality. We'll have accordingly admit it. Tell us. Show us.
My lord, the tribunal, my lord, did not consider the linkage, my lord. The link, my lord, sufficient link document, my
Which
lord.
is your link document?
My link document, page number 21, maybe seen, my lord. One of the link document, my lord.
One of the link document
My lord.
21.
21.
Ah.
Mavia Khatun, my lord, father's name is there, my lord. Kasam, late Kasam, my lord.
Ah.
So, my lord, next, my
Late
lord,
Kasam. Very good.
then, my lord, page 22, this is another certificate, my lord, Kasam Ali. My lord, Ali was not there earlier.
No, it's okay.
My
Kindly
lord.
read it.
Then,
as
my
a
lord,
whole.
page number 23, it's the Aadhaar card, my lord.
Sir Ali, kindly read page number 21 as a whole. Kindly read.
This is to certify that Mavia Bewa, daughter of the late Kasam, Jamalpur village, number 5, Boruazar, Gao Panchayat, under Dolgao, Revenue Circle, Dorong district of Dorong of Assam, who is aged about 50 years, was a resident of within the jurisdiction of the state Gao Panchayat area. Srimati Mavia got married in 1987 with the late Ramzan Ali, son of late Amiruddin, Mullapara village, Dolgao, Dorong. Mavia. Mavia Bewa has now migrated from the state Gao Panchayat area to the above mentioned location by virtue of her marriage, which was solemnized as aforesaid. This certificate is issued based on the evidence placed before me. Signature, Secretary, Gao Panchayat Secretary.
So this is only for the purpose of NRC, right? Anyway, even then, you are claiming that you are a resident of Damalpur after your marriage.
My lord. No, my lord, she was originally Jamalpur, and after marriage, my lord, Dolgao, after marriage,
Which village?
Mullapara.
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 So you said you are a resident of Jamalpur.
Resident Jamalpur, father's resident. my lord.
Come to page number 20. Whether that document is right, wrong, we are not on that. Kindly read.
My lord, after expiry of her father, my lord, she came back, actually. Repeated check.
Huh?
After expiry
Kindly
of her
read
father.
page 22.
Mavia Deva, daughter of late Kasamali village, Kokal Bhangi, Jogi Jan, post office, Dolgaon. The villages. Moza, Posim Dolgao, PS Dolgao, district Dorang Assam.
So,
So some shifting when it after
Where
expiry
is
of
that?
her, after
where is that? That's why we're asking you each and everything. Kindly clarify.
my lord, while her
Come to page
husband,
number 30. Listen. Come to page number 30.
page number 30, 30 is a document, Aadhaar card of her brother, my lord, Nur
Yes.
Islam.
Read this. Read the lower part of page 30. What is the address?
Address, care of Custom Ali, house number, also.
So that Qasim Ali is alive.
Dolgaon, my lord.
That Qasim Ali.
Hmm.
And this is Aadhaar card issued when? When did the Aadhaar card was issued? When did the Aadhaar Act came into force for the state of Assam? You are a resident of Dolgaon Kuti.
My lord.
Good. Come to the voter list.
Uh,
At page number 29,
Page
28,
number, my lord,
page number 28, where you are claiming that your father brother's name is in the voter list. Which village?
my lord, page number 28 is the voter list, my lord, where my brother's name is there. My lord,
Which
my name is
village?
there, my lord.
We are not asking that. We are asking for your brothers. Which village?
My lord, village page number 32 may be seen, my lord.
Kindly see at page number 28. Village of your
28, yes, my
brother,
lord. Village is, my lord,
the top, it is there.
village Dolgaon Khuti.
Village Dolgaon Kuti.
Dolgaon
Your
Khuti,
Aadhaar card also says, the brother of the Aadhaar card also says Dolgaon Kuti.
my lord. And my lord, page number 32, my lord, Dolgaon Khuti, my lord.
Come to page number 23. What is your address?
Address, my lord, Jogi, Kokal Bhangi, Jogigaon.
The certificate it was issued by the Gaon Panchayat. You resident of which village?
Earlier, my lord, Jamalpur, thereafter Mullapara, my lord.
How will you collect it? Which
My lord,
document will show that? Because you see from your brother's address, care of Qasim Ali, Dolgaon Kuti.
my lord, several
Who is
times
this
shifting,
Qasim Ali?
several times, my lord, shifting, my lord. I
Have
have
you mentioned
taken,
somewhere? You have said that earlier, the petitioner, as per that Gaon Panchayat certificate, whether it was issued rightly, wrongly, you are not on that. Again, you are repeating that you are a resident of Jamalpur, and after your marriage, you are a resident of Mullapara.
Hmm.
So where is this,
My lord,
all these come? Tell us.
my lord, actually, I have taken instruction that since the WSN evidence could not be collected in those documents, my lord, the shifting, my lord, everything, my lord, were narrated there, my lord. Because, my lord, they
Now let us see
other,
where you have stated in your read petition that you have shifted from one place to another. Tell us. Slide number 2. Where you have stated of shifting. Read para number 2.
yes, the petitioner is a bona fide citizen of India who is having all requisite documents to be a citizen of India. She was born and brought up at village Jamalpur under the Dolgaon police station of Dorang district, and she was married to one late Ramzan Ali village Mullapara under Dolgaon police station of Dorang district. At the time of her marriage, she was under age of 18 years, and as such, her name was not enlisted in the voter list with her father, but her name was duly enlisted with her husband after her marriage. She is having sufficient link documents. Now she is residing at Dolgao Kuti under uh, under the police station of Dolgao in the district of Dorong, Assam. Uh,
Yes, yes.
the so my lord, she is not a suspected citizen.
Hmm.
There are three, my lord. The petitioner's father, Kastom Ali alias Kastom Ali, issued NRC in 1966 and 71, whose name also appeared in the voter list of 1966 and 71. And she casted votes along with his family members at village Jamalpur under Dolgao LSD in the district of Dorong, Assam. Well, Para 4, I have stated that the petitioner is having linked document with her father, who is a voter in an NRC holder in 1966 and 71. The petitioner was issued sponsor certificate on 26/15 Gao Bora certificate census to certify that her linkage with her father. Government of India issued Aadhaar card, PAN card by showing the date of birth, father's name, and residential status after scrutinizing her entire record.
Please come to page number 22.
Page number
When it was issued,
and it was issued 2000 2023, madam.
date
Uh, 3/3/2023.
3/6/2023.
My lord.
Please come to page number 39. What is the date of the order?
Thirteen 2023.
So this particular annexer at page
My lord,
22.
this was not exhibited, my lord. I
This
have
was
collected
not.
letter and I have annexed, my lord.
Now please come to page number 44. Just read exhibit 10, second paragraph.
Exhibit 10 is the certificate is dated 6/12/2021 issued by Gabura of Dolgao Kuti, certifying that opposite party is the wife of Ramzan Ali of village Dolgao Kuti. This certificate does not prove.
Whether have you annexed this document?
No, I could not annex, my lord.
You could not annex,
My lord, it was exhibited in
or you
the
did not
tribunal.
annex.
It was exhibited in the tribunal, my lord. The copy, my lord, we are not having. That is why, my lord, we could not obtain that, my lord. Elsewhere, my lord, in the elsewhere it is available. London tribunal correctly, my lord, observed that the shifting is there, my lord.
হিরেন গুহায় এখন হিরেন গুহায় edited English. Please take your seat. Mr. Sharma, what do you have to say?
Lordship, tribunal's order is Lordship. Very elaborate order has been passed by the tribunal, Lordship. Everything has been discussed, Lordship. And Lordship, to establish our link, Lordship, he produced Gabura certificate as well as Panchat certificate, Lordship. That was also discussed before the tribunal, Lordship. And if these two certificate has gone, Lordship, only brother's evidence will remain, Lordship, in this case. So, mm, and brother Noor Islam, Lordship, projected brother, he also could not establish his link with Lordship Kasam Ali, who is a voter of 1966 Lordship of village Jamalpur, Lordship. And Kasam Ali of 1966 voter list Lordship of village Jamalpur, as well as Lordship Nuruddin, son of Kasem Ali, placed before the, it was not exhibited, perhaps, Lordship. It is not a certified copy, Lordship. Page 28, Lordship. It is of different village, Lordship. So this Kasem Ali, Nur Islam, Ita Kasem Ali, Lordship. This Kasem Ali in 1966, voter list Kasem Ali are not same in 1%, Lordship. And Lordship, if we consider the present age of the petitioner, Lordship, he is sometimes born in the year, Lordship.
Three.
Yes, Lordship. Then so our first voting right, Lordship, started from the year 1986, Lordship.
84,
Yes,
because the amendment was only in the year 1989.
yes, Lordship.
So till then it was 21 years.
Yes, Lordship.
So 63 plus 21 is 84.
Yes, yes, Lordship. But Lordship, here, Lordship, petitioner has placed only 2013 voter list at the age of 49 years. Mabia Bewa, Lordship. Prior to that, Lordship, no voter list is there, Lordship. And Lordship, apparently, Lordship, petitioner could not able to establish his link with Kasem Ali of Jamalgaon, Lordship, which existed in the year 1966, Lordship.
Good. Good. Not Mr. Ali. Body petition. These are not. Or- Six. Yeah, yeah. Peter. After hearing the petition, considering the evidence adduced by her, the learned foreigners tribunal fifth Dorong Murray. By the impugn opinion, date 13/02/2023, declared the petitioner to be a foreigner plus illegal migrant under the Foreigners Act 1946. Hence, this petition by the petition filed on 29/11/22. Peruse the impugn order dated 13 to 20. Before proceeding further, we propose to peruse the relevant record. Yeah, for the order to the F.P. of the Secretary. Yes, process to the arising from F.P. of the Secretary of Statistics 7. Propose to the propose to the record. Say F.P. for a date of the resistance immediate receipt of the bill.
My lord, dispose of my lord.
No. Record to
My lord, heard that the petitioner is ill, my lord. Some time may be granted, I may be contact with the petitioner, my lord. For the last almost 2 years, when I have no contact with. Some time may be granted.
So, who gave you the information that the petitioner is ill?
My lord, one person, my lord, a person who contacted this case, my lord, earlier. Heard that, my lord, one of his neighbors saying that. My lord,
So, tell us, when did she appear reported concerned Superintendent of Police border? That you have to tell us to consider your,
I have appeared, my lord, at that.
when? That's what we want to know from you.
Some time may be granted. I'll take all information, my lord. I'll take all information.
Notice of motion was issued 19th of May 2017. You took time on 21st of February 2019. Again took time on 4th of April 2019. Thereafter, you took time on 14th of November 2019. And lastly, on 17/11/2023. What else you need?
My lord, in fact, my lord,
It's all your name.
contract is lost, my lord, at the last some days.
Did
My
not
lord.
state anything.
Only my lord, last opportunity, my lord. I'll take all everything information for the sake of the case, my lord.
Sixth. Sixth.
My lord, it may be on 7th.
No bargaining here. You are not in the market. Taken sufficient time. On the prayer of Mr. Richard Chaudhary, counsel for the petition. That is adjourned for the date. Placed on 6th. No further time shall be granted to the petitioner. In the fact that since 2017, May, she is enjoying the interim.
May I just- In this case,
Yes,
my lord,
Mr. Sinha.
in this case, my lord, another two connected case was there. Stator was called for another case, my lord.
Huh? Why do you need Mr. Sinha another day?
Lordship has the impugnated at 29. There is a ex parte order, my lord. Petitioner are among three person, my lord. Petitioner number 2 is appeared before your lordship, my lord. And other your lordship has asked the standing counsel to make the status of case number 1 and 2, FTT 507 and FTD 513, my lord. Whether he is appeared before your lordship or not.
Regarding lordship, petitioner number, proceeding number 1 and 3, lordship. The concerned authority, lordship, could not find any record regarding lordship they approached before the high court or not, lordship.
Mr. Sharma, you
Lordship.
passed an order earlier on 28th of November. Wanted to know the status of the other two cases. What happened? The 45. What happened? The opinion you have seen, there are two other connected cases, right?
Yes, lordship. That,
We wanted to know. The reason is very clear.
yes, lordship.
This order was passed in 2009.
Yeah.
Whether the persons mentioned that they were taken into custody, deported or what,
Lordship, at 2, I will take the instruction, lordship.
you have to tell us. Because there is no stay order from the court.
Yes, lordship.
Yes, Mr.
Enabling lord. My lord,
Ms. Begum, in the absence of Mr. Gogoi, you have been appointed on the MICA. But when the concerned council engaged by the petitioner is present, the last occasion evidence is today. We'll be hearing only Mr. Gogoi. Thank you that you have assisted the court at the last. We appreciate your. Yes, Mr.
May please the lordship. I beg to say certain point here, my lord. I beg to say certain point, my lord.
Observing that. The engaged counsel of the petition remain absent on 30/03/2022. As well as the next deadline on 20th/11/2023. The court by order dated 20th/04/2023 appointed MS P. Begum, learned counsel, to act as an amicus curiae. However, on the next date of the thief of the matter, next dates. Mr. C. Gogoi, the engaged counsel of the petition, appeared in a matter on 15/11/2020. 22/11/2020. And in view of the above, we relieve MS P. Begum, planted a McGrath School. Appreciating her service in assisting the court. Last. Okay. Last date. 15/11/2023. Yeah. 20. As on both. We heard for some time. Yes, Mr. Gupta.
Yes. My lord. I beg to say certain points, my lord, in this case. The voter ID of Joygun Nessa. The voter ID of
Ah.
Joygun Nessa, mother of the petitioner, my lord.
Annex which annex?
Exhibit. Exhibit.
You are relying on the records or the annex was happened in the.
Exhibit 11, my lord. Page, my lord,
Mr.
page
Gogoi.
20. Page 20, my lord.
Mr. Gogoi,
Yes, my lord.
straight away take us to the impugn judgment.
My lord.
Straight away take us to the impugn judgment. We'll come back to the relevant exhibits later on. Come to
Page, my lord.
page number 15, para 3. You start from para 3.
Karachi. In due course, the said OPDW1, namely Mustafa Nessa, has adduced his own evidence as DW1, both oral and documentary, whereas the mother of the said OPDW1, namely Mustafa Zaigun Nessa, has laid her evidence as DW2 to support the Indian citizenship claim of her daughter, that is OPDW1. Both of them were duly cross-examined. Exhibit 1 is a certified copy of a sale deed dated 1957, which as per the DWs 1 and 2, the same was executed by and between one Muhammad Janawali, purchaser, and Muhammad Mubarak Ali, seller. In order to check the adequacy of the said Exhibit 1 sale deed, I therefore consider it necessary to have a bird's eye view and a statement in course of the state DWs 1 and 2, more particularly the DW2, namely Mustafa Sulaiman Nessa, who is the mother of the said DW1. The said DW2 has disclosed in her cross that the name of her father-in-law, Opi's grandmother, was late Muzammil Ali, who, as per the DW2, had expired prior to her marriage with the father of the DW1, namely late Junawali. In Exhibit 1, though the name of the husband of the said DW2 is rightly mentioned as Junawali, but her father-in-law's name, that is Muzammil Ali, is not recorded in his actual name, and the said name has been incorrectly reflected as Mujibur Ali. The Exhibit 1 is a copy of the title deed in respect of the husband, that is Junab Ali, and assertion of the said name in correct manner cannot be rectified by any means or manner therein. Therefore, it presumed that the purchaser of the said sale deed, Exhibit 1, was not the husband of the said DW2, but it was another person in the same name, like the name of the husband of the said DW2, that is Junab Ali, who was the son of the Mujibur Ali. The said name of the Mujibur Ali was not the name of the father-in-law of the said DW2. Moreover, the sale deed Exhibit 1 is not proved in accordance with the provision contained in Chapter 5 of the Indian Evidence Act 1872, and also in view of the decision of the Honorable Apex Court report in 2010, 4th SCC 491, as such, the same cannot be constituted to be a valid document evidence in support of the Indian citizenship status of the state OPDW1. And Exhibit 2. 2 is a school certificate dated 23/2/2005 issued by the headmaster in charge of the Daboga Girls High School, Post Office Daboga, District Nagaon, Assam, certifying thereby that Mustafa Piarun Nessa, daughter of Junawali, was a student of the said school, who had prosecuted her study up to class 7 in the said school and left her schooling on 31/12/1991. The said school certificate Exhibit 2 has been issued on 23/2/2005 after a gap of 14 years, which is not even been countersigned by any education authority of the state. Moreover, the said school certificate Exhibit 2 has not been proved in accordance with the provisions contained in Chapter 5 of the Indian Evidence Act 1872, and also in view of the Honorable Apex Court decision reported in 4 SSC 491, and as such the same has no evidentiary value. Exhibit 3 is a certificate issued by to the said OP DW1 by the Secretary of Akasi Ganga Gaon Panchayat. However, in view of the judgment dated 28/2/2017, passed by the Honorable Guwahati High Court, Division Bench in WPC number 2634/2016, since such certificate has no sanctity of law, hence it cannot be accepted as a valid documentary evidence. 4. Exhibit 4. Certified copy of the voter list of 1966, wherein as claimed for by the state DWs 1 and 2, more particularly by the DW2, with the mother of the state DW1, her father-in-law's name has been recorded at serial number 114 as Mazlim Ali. Although the said name ought to have mentioned correctly as Muzammil Ali,
the father-in-law of the said OPDW2. At serial numbers 115 and 116, the names of the deceased husband of the said DW2, that is Donavali, is recorded along with the name of the DW2 herself, together with the name of the brother-in-law of the DW2, uncle's name of the DW1, that is Habib Ali, who is ought to have Habib Ali as disclosed by the DW1 in her shares. It is relevant in this connection to mention herein that the said DW2, the mother of the said DW1, has stated at her statement in cross by very clearly that her father-in-law, namely Muzammil Ali, had expired prior to her marriage with Junab Ali. The present age of the said DW2, as disclosed by her in cross, is 70 years, and in that way, her year of birth would fall sometime in the year of 1940. Needless to say that in the year of 1966, the age of the said DW2 was 26 years, and at that age, more particularly in the rural areas, a lady cannot be expected to be an unmarried one. It therefore presumed that the father-in-law ought not to have survived in the year of 1966. The report Exhibit 10, which is the NRC voter details of the husband of the said DW2 and father of the said DW1, that is Junab Ali, is recorded, was the son of late Muzammil Ali. The said NRC voter details is of the vote year of 1966, having in the name of the voter, that is Junab Ali, whose name should have been mentioned as serial number 123, block number 126, having the age of the voter in the said year, that is in 1966, as 31 years. Now reverting back to Exhibit 4, voter list of 1966 as per Exhibit 10, NRC voter list of 1966, name of Junab Ali, who was the son of Muzammil Ali, his name must have been recorded as serial number 133 of the vote year of 1966. But surprisingly, this name is recorded at serial number 115 of the certified copy of the voter list of 1966. Again, the block number in Exhibit 10 for the same vote year, that is 1966, is 126, whereas the block number of the same year in Exhibit 4 is 124. Further, the age of the voter as per the NRC voter details of 1966, Exhibit 10, is 31 years, whereas the age of the same person in the certified copy of the voter list, Exhibit 4, is 35 years. It seems the serial number of the voter whose name is recorded as serial number 115, having his father's name as Muslim, and whose age is 35 years in 1966, was not the same person whose name is recorded in the NRC voter details of the same year, that is in 1966 itself, Exhibit 10. The aforesaid details of the voter as discussed above have no consistency in Exhibit 4 with that which recorded in Exhibit 10, rendering the same to be the most untrustworthy and unreliable. Exhibit 5 is a certified copy of the voter list 1970 in respect to the same set of persons whose names are recorded in Exhibit 4, voter list of 1966. However, in view of the discussion as made in respect of Exhibit 4 and 10 above, I therefore do not find any necessity to discuss the discrepancies of Exhibit 5, and the same is not as noticed in respect of the Exhibit 4 is hereby reiterated and not repeated again. Exhibit 6, 7, and 8 are the certified copies of voter list for the vote years of 2005, 10, and 1997, respectively. However, since these exhibits are not having proper linkage with Exhibit 4, 5, and 10, and the same are not attended separately, moreover, the voters whose names are recorded in Exhibit 6, 7, and 8 are the descendants of late Junab Ali, the husband of the DW2 and father of the DW1. But as the names of Junab Ali and his own identity is in dispute in Exhibit 4 and 5 with that of Exhibit 10, hence reliability thereof are completely in question. More, the computer downloaded copy, that is Exhibit 10, is not admissible as a valid documentary evidence in the eyes of law. Although this same shall be treated as a mirror of the certified copy of the voter list of the same year, there is hardly any possibility to deviate any details from the NRC details of 1966 with that of the certified copies of 1966 and 1970 respectively. In the case at hand, the details entries of Exhibit 4 and 5 doesn't have any consistency with Exhibit 10, and as such, Exhibit 4 and 5 have no reliability in any manner. Exhibit 9 is a certificate of residency issued by the DW1, namely Mr. Pierre Hussein Nessa, on 25/2/2015 by the government Gampura of Burigaon village However, since the same is not proved in accordance with the provisions of Indian Evidence Act 1872, as such, the same is of no use in support of the said claim of the said OPDW1. Exhibit 11 is the proved in original copy of the voter's identity of the said DW2. However, since the proceeding is not pending against the said DW2, and hence the same is not acted upon. Exhibits 12 and 13 are a copy of the land revenue paid receipt and the original copy of the Jawabandi for the surveyed villages. On careful perusal of Exhibit 13, more particularly, there is nothing to show in the said Jawabandi as to what was the source in recording the name of Muhammad Junab Ali, son of Muzamil, whose name is recorded at of serial number 123 of the said Jawabandi. In order to show someone as particular of a land, his name must have been mutated in the relevant land records only thereafter, thus name could be entered into the Jawabandi of the land. In the case at hand, no such legal requirement has been followed. It also appears that Exhibits 12 and 13 has no connection with Exhibit 1 cell deed. Moreover, these are also not proved in accordance with the provisions of law, hence no relevance thereof. On conclusion of a trial as contemplated by the order of 1964 as amended up to date, the Learned Council appearing for the said OP has therefore good that the documents produced and exhibited with evidence of OP and DW1 have the absolute authenticity and adequacy in succession of her claim of Indian citizenship. The Learned Council has also argued the documents executed and relied upon by the DW1 have evidence that constitute indivisible testimony of her claim of Indian nationality, and the same cannot be disbelieved in any manner. I have analyzed the entire evidence of the OP, DW1, and DW2, and the documents accompanying the return. So peruse the materials available on the record. The statements made in the evidence of the OP, DW1, and DW2 pertaining to the documents of the OP exhibited therewith have therefore not been affirmed at all as required in law, and thus are of no evidentiary relevance. Moreover, as held by the Honorable Apex Court in 2002 for SCC 346, mere long stay in the country and enrollment of the name in a voter's list did not confer any right to continue to stay in the country. 6. The set of documentary evidence produced by the OP, DW1 and DW2 would demonstrate our bearing cross discrepancy and inconsistency, rendering the same untrustworthy and unreliable. The OP, DW1 has therefore absolutely failed to discharge her mandatory burden to prove that she is an Indian citizen and not a foreigner at ambiguous in Section 9 of the Foreigners Act 1946 as amended up to date. In view of the matter, declare foreigner.
Whether the Gowra adduced evidence?
No, my lord. I'm relying upon my lord, documents, the school certificate issued by the headmaster
The
of the school.
concerned issuing authority of that particular certificate was examined.
No, my lord. Had they, my lord, summoned them, my lord, they would have definitely appeared, my lord.
It is the
Pardon?
proceedings case.
Learned tribunal could have, my lord, examined them, my lord.
It is the proceedings case and
So in the interest of
You
the
is
city,
required
that ought to have done, my lord, ought to have been done. For the fault of a lawyer, my lord, and other authorities, my lord, the petitioner should not suffer, my lord.
it is not the lawyer's case.
He is defending, my lord. And at that, when the, my
That
lord,
case, all the tribunal decision has to go back.
my lord, the documents were executed, but at that time, the prosecution has not raised any objection, my lord. Once it is admitted, my lord, the letter, at the letter, said that cannot be entered in, my lord.
That's right.
My lord. The prosecution ought to
Mr.
have raised it earlier, my lord.
Is proceeding to replace. Let us take up that particular certificate. When it was obtained,
Certificate is not available with me, my lord. I could not
when
find
it
it,
was obtained.
my lord.
When it was obtained. When it was.
Twenty-three to 2005, my lord. And page is, page 45.
Take your say.
Yes, my lord.
Have you gone through the records, Mr. Gogoi?
Yes, ma'am.
Mr. Sharma, have you gone through the records? Have you gone through the records or not?
Lordship. Earlier I have done to, but Lordship, something have to recollect, Lordship. I want to see again that. Hmm? Hmm. Hmm. Only thing, Lordship, link document is not proof, Lordship.
Huh?
Link document is not proof. What order? Venkatesh, Lordship. I have seen from the order, Lordship. And Lordship, mother's evidence cannot be accepted for the purpose of link, Lordship. And the rest. Without documentary support, Lordship. Hmm? There are also contradiction between exhibit 4 and exhibit 10. Lord. Hmm? Hmm. We are on next. Huh? Diana, Diana. Diana. The certificate है या तो बैठ के देना ये है मैं क्या हो रहा है कितने का evidence এখানে 38 years. India of 2015. Hmm. 18 plus 18.
Man, my lord.
No, my lord.
My lord.
Yes.
Delhi. Muzammil. Muzammil. Yes, ma'am. Muzamil. But she has stated petitioner is her daughter of her daughter. Yes, ma'am.
Written statement of the opposite party, Muhammad Piarun Nessa, wife of Gyasuddin, daughter of late Junawali, village Nom Doboka, Gaon, PS Doboka district, No, Nagaon. Sir, most respectfully, your humble opposite party begs to submit as follows: that no cause of action for institution of the national institution of the ori- originally
Notice case.
noti- notice case against the opposite party. Hence, the case is not maintainable in law. That opposite party is a bona fide citizen of India by birth, and she was not intimated in relation to the suspicion of the investigated agency, or even any documents was asked for in support of her citizenship by the investigated agency. Okay, mechanically, this case was instituted against the opposite party without any reason. Hence, the case is not maintainable in law. That the opposite party is not foreigner as alleged. He is a bona fide citizen of India by birth. The opposite party, Muhammad Piarun Nessa, was born on 31/10/1978 in her paternal house at village Burigao, PS Doboka, district Nogao. According to the school transfer certificate of Doboka Girls High School, Doboka, Nogao, Assam, as Annexure 1, that the secretary of Akasigonga Gao Panchayat has issued a correction certificate, had issued a
Mary's concern.
marriage consent certificate. Marriage consent certificate in the name of opposite party file number AGP insurance show dated 25/6/2015, Annexure 2, that the father's name of the opposite party namely Junab Ali alias Junab Ghosh, name has been entered in the voter list of 1966 of 92 number Jomunamukh LAC flight serial number 115 house number 33 part number 124 of village Burigao PS Jomunamukh district Nagaon Assam as annexure 3. That the father's name of the opposite party, namely Junab Ali alias Junab Ghosh, name was recorded in the voter list of 1970 of 92 number Jomunamukh LAC by serial number 115, house number 33, part number 124 of village Burigao, PS Jomunamukh district Nagaon, Assam as annexure 4. That the father's name of the opposite party, namely Junab Ali Ghosh, name has been recorded in the NRC Assam voter details 1966 by Office of the State Coordinator of National Registration file legacy data number so and so image ID PS Jomunamukh district Nagaon Assam as annexure 5. The father's name of opposite party, namely Junab Ali Ghosh, name has enlisted in the voter list. Yes. Oh, whose name? Yes, Lord. That the father's name of the opposite party, namely Junab Ali, whose name has been enlisted in the voter list of 1997 of 90 number Jomunamukh LAC by serial number 163, house number 163, part number 142, village Dighol Joroni Forest, village Dighol Joroni Forest, village PS Doboka district Nagaon Assam as annexure 6. That the name of the opposite party, whose name did not enter in the voter list of 1997 of 91 number Hosea LAC by serial number 913, house number 290, part number 15 of village Non Doboka Gaon, PS Doboka district Nagaon Assam with her family members due to the voters. That the mother's name of the opposite party, whose name has enlisted in the voter list of 2005 of 90 number Jomunamukh LAC by number 653, house number 180, part number 61 of village Burigao, PS Doboka district Nagaon Assam as annexure 7. That the mother's name of the opposite party, whose name has been recorded in the voter list of 2010 of 90 number Jomunamukh LAC by serial number 752, house number 180, part number 72 of village Burigao, PS Doboka district Nagaon Assam as annexure 8. That the father of the opposite party, namely Muhammad Junab Ali, who was purchased land from one Muhammad Mubarak Ali and made a registered sale deed in between both of them in the year 1953 by registered sale deed number serial number is T201 and 2118 dated 1957 annexure 9. Did the government Gaubura of Burigao and কি গাঁও এটা? The government Gaubura of Burigao and others Gao has issued a certificate in the name of opposite party by book number 2 and serial number 195 dated 25/2/2015 annexure 10 that the opposite party will be able to prove her case by documentary evidence and also adducing evidence or else written evidence to substantiate her nationality, that she is an Indian citizen, that the authority since files this case only to harass the opposite party physically, mentally, and financially without providing opportunity for filing the document that the opposite party is an Indian citizen and residing at the above noted address, and she will be able to prove her case, and she did not enter India after 25th March 1971. Hence, the case is not maintainable in law and liable to be dismissed. In the premises aforesaid, it is therefore prayed that Your Honor may be kindly be pleased to accept the written statement of the opposite party. That's all, Lord. মোৰ নাম মৌচম পিয়াৰুন নেছা, বয়স 38 বছৰ, স্বামীৰ নাম মোহাম্মদ গিয়াছুদ্দিন, ঠিকনা গাঁও নাম দবকা, গাঁৱৰ ডাকু থানা দবকা, জিলা হোজাই, অসম। মোৰ জন্ম গাঁও বুঢ়ীগাঁও, ডাকু থানা দবকাৰ অন্তৰ্গত হৈছিল। মই ক্লাছ 7লৈ পঢ়িছো দবকা গাৰ্লছ হাইস্কুলত। মোৰ ককাৰ নাম মৃত মুজাম্মিল আলী আৰু আইতাৰ নাম মৃত আমিনা বেগম। এওঁলোক বুঢ়ীগাঁৱৰ মূল বাসিন্দা আছিল। মোৰ দেউতাৰ নাম মৃত জোনাব আলী আৰু মাৰ নাম মছমত জয়গুণ নেছা, বয়স 70 বছৰ। মোৰ দেউতাই যোৱা 16 বছৰ আগতে 80 বছৰ বয়সত ঢুকাইছিল। এওঁলোকেও বুঢ়ীগাঁৱৰ বাসিন্দা আছিল। মোৰ দেউতা দুজনে ককাই ভাই আছিল আৰু দুয়োজনে একেলগে বসবাস কৰিছিল। ডাঙৰজন মোৰ দেউতা আৰু সৰু খুৰাৰ নাম মৃত হবিব আলী। যোৱা 30 বছৰ আগতে তেওঁৰ মৃত্যু হ'ল। তেওঁৰ পত্নী ব্ৰেকেটত খুৰি মোৰ পত্নীৰ নাম মই নাজানো। মোৰ দুজন ককায়েক আছে, দুয়োজনে একেলগে থাকে বুঢ়ীগাঁৱতে। 1 নং মোহাম্মদ ইলাছ আলী, বয়স 50 বছৰ আৰু 2 নং মতলিব আলী, বয়স 40 বছৰ। এওঁলোকৰ মাজত মোৰ দুজনী ডাঙৰ বাইদেউ আছে। মোৰ বিয়া যোৱা 20 বছৰ আগতে নাম দবকা গাঁৱৰ বাসিন্দা মৃত মছায়দ আলীৰ পুত্ৰ মোহাম্মদ গিয়াছুদ্দিনৰ লগত হৈছিল। 1997 চনৰ পৰা মোৰ নামৰ লগত ডি লগাৰ কাৰণে তেতিয়াৰ পৰা মোৰ নাম ভোটাৰ তালিকাত অন্তৰ্ভুক্ত হোৱা নাই। এক্সিবিট 1 to 13 বিষয়ে মোৰ স্বাক্ষৰ জৰিয়তে সোধপোছ কৰি লিখা ধৰণে একে হয়। এক্সিবিট 1 to 13 বিষয়ে মোৰ স্বাক্ষৰ জেৰাত সোধপোছ কৰি লিখা ধৰণে একেই হয়। মই জন্মগত ভাৰতীয় নাগৰিক হওঁ, বিদেশী নহওঁ। Yes, Lord. Yes, Lord. Yes. Yes, Lord. Yes, Lord. Yes, Lord. জোনাব আলী, মুজাম্মিল আলী, মুজাম্মিল। জোনাব আলী পিতা মুজাবির আলী। Yes, Lordship. Yes, Lord. Muzamil. 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 Muzamil Ali. Not that Ali is not. Yes, Lord. Yes, Lordship. Muzamil Ali. Yes. Lordship. Borabor. Borabor. You know, Muzabir Ali. Yes. Gavura. Gavura certificate. Yes. 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 Mm. That was not mentioned. Yes. 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 Yes.
His name will be in there, yes, your lordship. Mark as D, and he will not be allowed to vote, your lordship. Yes, but his name will. No, it will be there. Only as is doubtful, he will not be deleted, your lordship. Until unless the judicial order is passed, his name will not be deleted. And it has been happened by this honorable court. The procedure is your lordship.
None. Yes, Lord.
No, not that. No.
Moderate. Mm. Mhm. Mm. Yes, Lord. মৃত্যু হওয়া ১৬ বছর হল না, এবং মৃত্যু ৩০ বছর আগতে দেউৰে ঢুকাইছিল তেওঁৰ মোৰ ল'ৰা দুজন Yes, Lordship. বয়স 45 বছৰ আৰু yes, yes, দুয়োজন একেলগে থাকে ইলফিডিন আৰু yes, mostly Bali, but
A clear picture will be emerged if they are examined, my lord. If they are examined, my lord, a clear picture will emerge. Yes, my lord. In the interest of the case, we remand back this or remand back, my lord, for retrial, my lord. Because the authors of that particular document, my lord, don't examine, my lord. Who could, therefore could not establish the linkage with her father. Yes, my if an opportunity is granted, my lord. Because my lord, yes, yes, my lord, non-examination of the authors, my lord. It amounts to violative of principle and assault justice, because yes.
I have there before, Lord. If Lordship may permit me to say something on this project. Yeah.
No, Your Lordship. I can see my lords have taken situation. Lordship, there are only three issues. Of course, today. Yeah, that is the review which we are seeking. Today. 8th of December. Will it be convenient for the fifth I can accommodate?
Moving forward, very cool. Monday. Like.
Yes, lordship, I have one altered method in Canada. Is it possible? Six also for difficulty, but seventh I am available. Yes. But I take a chance on fifth and that. I will need about at least 10 minutes. It's purely legal issue. Fact, obviously, there's no dispute on the other side. So, we will inform him. Okay, no issue. My associate has a case in 44. Trial with both for lordship, I have a CBI case in that case. And arguments have to take place on bail. Seventh I can, yes. Someone will try to prove it. You have to travel from. No issue there. I will go late by last flight. Also, I'm taking the last flight at 9 p.m. My lord, that's a fixed item number one. No, I mean like on seven. On seven, kindly promoted as a fixed item number one. For the past 6 times, it has been adjourned because election and my lords can take the first item of your match. I think we can conclude it. There are no issue. Much of
My lord, only thing is that, my lord, they were not examined. No, I'm not blaming anyone, my lord. That's totally allowed.
Lordship, on last occasion, I have gone through the LCR, Lordship. So I have a limited submission, Lordship. Lordship, 2 references are made to the petitioner. One, yes, clubbed together, and order was passed on FT 84, 2015. Lordship on that. Lordship, on the FTD 1435 stroke 2015 in that reference, Lordship, petitioner's name is depicted as Piarun, whereas I haven't found any supporting document regarding this name, Lordship. Number 1. Number 2, I rely on voter list of 1966, 1970, where the petitioner's parents' name enlisted, Lordship, as Jaigonnasa as wife of Janab Ali, Lordship. After that, petitioner filed WS evidences of DWs, where she stated. Yeah.
Yes. This is voter list of 1956 Lordship. Yes, Lordship. Yes, Lordship. Exhibit 10. House number, Lordship.
25.
20. House number. House number is not here, Lordship.
LSC.
LSC. Gurgaon. More copy to go. More copy to go. Yes, sir. Yes. Yes, sir. Yes, Lordship.
House number.
Office of the State selected Nagaon, village Burigaon. Junavali, Muzamil. Muzamil. Here, Muslim. Muslim Ali. Lordship. That is a voter serial number 133.
92.
115. 115. LSC 92, Jumna Mukh.
Circle Hussain. Circle Musa District Nagaon, Circle Hussain.
Circle Hosai. Then Lordship, subdivision name Jumna Mukh. Subdivision name is not there. Thana Town Jumna Mukh.
Mohkuma says Musa Jamuna Mukh. Mohkuma is Jila Nagaon. Thana Jamuna Block 126 Nong Jamuna Block will be not there. Age 31.
Age 31.
Age is 31.
Here age is 35. 35.
Yeah, somebody there.
There are contradiction between exhibit 10 and exhibit 4, Lordship.
Lordship, NRC details regarding which year? It is not mentioned the year.
Year 1966.
Oh, if I'm not
And
mistaken.
judgment in Milita.
Lordship, after that, Lordship, DW2 mother divorced herself, stating she is the mother of the petitioner, Lordship. The tribunal in its order, page number 16, Lordship, came to the conclusion that It would be the.
No,
Huh?
no,
Nanny.
not mentioned, Lordship.
Lordship has said, mother. Lordship, though direct, although, yes, I have only deposition of the DW2, WS. Lordship, I have, so I have said that the limited submission. Lordship. Also, last one voter identity card of Jaigun Nesa, wife of Jonab Ali,
That cannot be accepted.
resident of Burigaon, PS Dabaka, district Nagaon, page number 53. Also 1966 and the 1966 voter list, yes. Mozambique.
Muslim.
Ah.
Same.
Yeah. There is no direct link, Lordship, linkage certificate.
May I please, your lordship? My lord, I'm sorry, my lord. I beg to mention item 7, my lord, in which my lord LCR was called for and which is not received, my lord. May I pray for a date? Earlier, please.
My lord, the learned tribunal has already opined that since the same is not proved in accordance with the provisions of Indian Evidence Act, as such, the same is of no use in support of the said claim of the said OP and opposition. Clearly stated, my lord. Regarding the the author of the document has not been proved. My lord. Yes, ma'am. Yes, ma'am. Thank you. Page my lord 20 or 20 my lord, exhibit 9. The certificate of residence issued by the institute. 9 my lord. 9 is the certificate of residence issued to the said OP, DW1, namely Mustafa Piarun Nessa on 25/2/2015 by the government of Buriga village. However, here. No, so a chance may be granted. An opportunity may be granted. I speak to myself. Considering natural justice. Otherwise, she already failed to establish the linkage with her father. These are linked documents, madam.
Regarding food certificate, law is already, law has been set by the Supreme Court as well as the Honorable Court also. Regarding food certificate, full certificate has to be proved. Yes, sir. Yes, sir. 1958 supplementary SPC 304 lot. Hiratmal Singhi.
Chinmail,
1988 supplementary SPC 304.
Mr. Gogoi, take your. What is the other thing?
But by, I think, by accepting this, law of the or High Court also, in the case of Pomima Das Profit, WPC 3056 3056 Pera 12 and 13.
Read para 15 and 16 of the judgment of the Honorable Apex Court.
Yes, sir.
Do you have a copy of that judgment with you?
Yes, sir.
Read para 15, 16.
The High
Hmm.
the High Court held that in view of the alleged content in the exhibit 8, 9, 10, 11, and 12 proved by Anantaram Sharma, PWC, and Koilashundra Sapadia, PW, from the date of birth of Nissan and Suraj Prakash Joshi was proved, and on that assumption, it held that these candidates had attained more than 25 years of age from the date of their nomination. In our opinion, the High Court committed serious error. Section 35 of the Indian Exchange Act lays down that entry in any public official book register record stating a fact in issue or relevant fact and made by public servants in the discharge of his official duties, specially enjoined by the law of the country, is itself the relevant fact. To render a document admissible under Section 35, the conditions must be satisfied. Firstly, entry that is relied on must be one in a public or other official book, register, or record. Secondly, it must be an entry stating a fact in issue on relevant fact. And thirdly, it must be made by a public servant in discharge of his official duty or any other person in performance of the duty specially enjoined by law. An entry relating to date of birth made in the school register is relevant and admissible under Section 35 of the Act. But the entry regarding age of a person in a school register is of not much evidentiary value to prove the age of the person in the absence of the material on which the age was recorded. In Raja Janaknath Roy versus Jyotish Chandra Acharya Chaudhary, a division bench of Kolkata High Court, discarded the entry in school register but the age of a party to the suit on the ground that there was no evidence to show on what material the entry in the register about the age of plaintiff was made. The principle so laid down has been accepted by almost all the high courts in the country.
In addition to those decisions.
In addition to those decisions, the High Court of Allahabad, Bombay, Madras have considered the question of probative value of an entry regarding the date of birth made in the scholars register or in school certificate in election cases. The court have consistently held that the date of birth mentioned in the scholar register or a secondary school certificate has no probative value unless either of his parents are examined or the person on whose information the entry may have been made is examined. In Viratman Singh, in Brish Mohan Singh versus Priya Brat, a question arose whether the returned candidate had attained the age of 25 years on the date of his nomination. The High Court has set aside the election of the returned candidate on the ground that he was below the age of 25 years on the date of filing the nomination. The court set aside the order of the High Court and upheld the election of the returned candidate on the ground that the burden of proving that returned candidate had not attained the age of 25 years on the date of his nomination was on the election petitioner, and since he had failed to prove that the election of the returned candidate could not be set aside, the court held that the entry recorded in the birth register maintained by an illiterate chowkidar by somebody else at his request was not admissible and had no probative value within the Section 35 of the Indian Evidence Act. In Rammurthy versus State of Haryana, the date of birth of a girl mentioned in the school certificate was not accepted. However, in Muhammad Ikram Hussain versus State of UP, this court accepted the date of birth of a girl as mentioned in the school certificate as the date of birth mentioned therein and supported by an affidavit filed by the
So there is a case which you are relying upon is as per the section 35 of the Evidence Act, it is the duty on the person who wants to prove the link between the proceedee and projected father or mother. Unless it is proved as provided under section 35 by mere placing the certificate, won't be there. Right? But what happened in one of the case, the apex court considered the fact that it was the father of the girl who filed an affidavit. Here, it is in the name of Junabali. It is not the case that Junabali has filed an affidavit stating that she is my daughter. In the written statement, there is no mention the name of the mother. Right? Now, full certificate adduced as an evidence, an exhibit on behalf of the petitioner, was not proved by the issuing authority.
Yes.
So it is not under section 35 of
Yes.
the evidence.
Again, Lordship,
And that was followed in the subsequent judgment. In the case of
Onimadas,
Nimadas.
Lordship, Onimadas, Lordship. Lordship, regarding Lordship, oral evidence of mother, Lordship, I want to rely on a judgment of Dishonorable Court, WPC, in 1900/19, Lordship, Noor Begum versus Union of India,
1900,
/2019.
Nurul Hussain.
Noor Hussain, Noor Begum,
Noor
Noor
Begum.
Begum.
No, this is in the evidence act itself.
Yes,
Oral evidence,
not
evidentiary value.
yes.
Yes. Anything else?
Again, Lordship, in Romila Khatun's case, Lordship, it was that Lordship, page 4, Lordship, second para. It is tried that Romila Khatun, Lordship, WPC, Lordship, 3807/2016. 3807/2016, where it is tell that Lordship, it is tried that documentary evidence would have to be proved on the basis of the record, and contemporaneous record must substantiate and prove the contents of the
Section
document.
35 of the Evidence Act.
Yes,
As
Lordship.
relied in this particular judgment, Biragmal Singhvi.
Yes, Lordship. Proof of document is one thing, proof of contents is another. Not only the document would have to be proved, but its contents.
yes.
should-
Yes. Anything else?
And regarding Gaura's certificate, Lordship, Kabir Khan's case is there, Lordship, WPC 4271/2019.
4271,
Yes, Lordship,
2019. What about the Gao Panchayat Secretary's certificate?
Yes, Lordship, regarding Panchayat certificate, Lordship, Supreme Court held in
Rupjan Begum.
Rupjan Begum, Lordship,
That is only for the purpose of
Mary domain.
marriage and shifting of their residence from
Yes,
one place
Lordship.
to other.
Yes, Lordship.
Right.
Yes, Lordship.
Whether it relates to the linkage,
No,
the apex court is totally silent about the linkage,
linkage, yes, Lordship.
but clarified that marriage is the marriage and shifting of the village
Yes,
after the
Lordship.
marriage.
Yes, Lordship.
What is the citation, Rupjan Begum, in the apex?
Lordship, I have, Lordship. Two 2018 1 SCC 579.
Anything you want to say?
That's all, Lordship.
Mr. Gogoi, it's a fact that the certificates adduced by the evidence adduced by the petitioner with regard to the school certificate, transfer certificate issued by the school authority, as well as the certificates that would be issued by the Gaon Panchayat, as well as the certificate issued by the Gaon Pura. In all these cases, these documents were not true, right? The names in the voter list, name in the NRC, and the name that figured in the CILD. Name of Junabali's father, totally different. 66 NRC, which is on the basis of the voter list, clearly reflects the different serial number. These are evident, leaving aside other. We have already said that name of mother was not specified in the written statement, nor the petitioner stated before in her written statement about the numbers of brothers or sisters she had. These have to be very specific. Let us assume Mr. Gogoi, in a
Lordship,
proceeding, a person considered to be a foreigner, suspected to be a foreigner, and his or her name has been referred to the tribe. What will be the bounden duty of the person concerned to prove himself or herself as an Indian, that she is not a foreigner or he is not a foreigner under the 1946 Act? What he or she is required to do?
even notices are upon him. Even notices.
Whatever the provisions of section 9 of the 1946 Act. Only thing is, to
Burden.
prove
Yes.
as per the 1946 Act and as per the citizenship. In both the occasions, it is fully on the duty of the proceeding concerned.
My lord.
The other things, the proof of documents, proof of statements will be as per the Evidence Act. As starts from 103, 105, 106, everything. Okay, we'll pass the order.
Okay. Obliged.
Pass the order. Well. Okay.
Sent it.
Yes, Mr. Sharma, what is the information you
Yes,
have?
Lordship, as per their record reveals that Lordship, petitioner number 3 expired and others are not in detention, Lordship.
Who is the petition number?
Proceed, Lordship, not petitioner. Proceed number 3. Page 29, Lordship.
Hassani Pal.
Page 23.
29, Lordship.
He expired.
Yes, 3. Petitioner number 3.
serial number.
No, in this case, only one petitioner.
Yes,
In this case,
Lordship.
one.
Only one, only proceeding number 2 is the petitioner here. Lordship. Lordship asks for regarding Lordship petitioner number 1 and 3. What is the status, their status at present, Lordship?
Then
Lordship, regarding
two?
three, regarding three, Lordship, he is
Expired.
expired. And others are not in detention, Lordship. That means present petitioner and proceeding number 1. Lordship.
pursuant to the order dated 2011-2023. Mr. G. Sharma, London Standing Hostel Home Department, Assam, on instruction submitted that the proceeding of FT within bracket D 513/07 reflected namely Sri Hassani Pal reflected in the order slash judgment of the order that is 06/05/2009 at serial number 3 has expired, and that the proceeding of FTD 508/07, namely Gopardhana Das, and the present petitioner, Srimati Josna Bishwas, involved in FT within bracket D 510/07. Those cases were decided. The relanded member for Furnace Tribunal First Morigaon on 06/05/2009 are not significant. Notice in this case was issued way back on 21/09/2017. Call for the records of FTT case number. Call for the records of FT D 508/07, FT within bracket D 510/07, and FT within bracket D 513/07 from the office of the Foreigners Tribunal First Morigaon, where by common judgment and order dated 06/05/2009, the said Foreigners Tribunal disposed of those three references, holding all of them to be foreigners. Under the Foreigners Act. Registry shall list this matter for admission immediately on receipt of the records.